And now to the Federal High Court, Abuja, where the court granted the application by the Economic and Financial Crimes Commission for the former Governor of Kogi, Yahaya Bello, to appear in court for his trial. Justice Emeka Nwite, in a ruling, held that the former governor ought to show respect to the court by appearing before it before making any application. Helen Osamide-Akins reports.
The reason given by counsel to Mr. Bello for his absence in court is that the former governor is not afraid of arraignment but safety of his life in the hands of the Economic and Financial Crimes Commission in Abuja. He said that the life of his clients has been under consistent threat in Abuja, hence his decision to go on the ground for safety. The agreement to submit to court trial was informed by the remarks of Justice Nwite that EFCC as a law-abiding body would not do anything against provisions of the law. The judge noted that Mr. Bello was not the first former governor to be merely invited by the anti-graft agency and would not be the last. He advised the senior lawyer to prevail on his clients to respect the law and order of court as a law-abiding person. Mr. Bello's lawyer, in response to the admonition, thanked the judge for the hints, adding that with the assurance that EFCC would not do anything until the former governor would be brought to the courts. The lawyer requested for 4 weeks to bring his clients before the courts. Mr. Bello would, however, come to the court instead of the EFCC to take his plea in the charges. Based on the undertaking and no opposition from the EFCC counsel, Rotimi Oyedepo, Justice Nwite fixed June 13th for Bello to appear in court for his plea to be taken.
The judge says Yahaya Bello staying away amounts to utter disregard to the sanity of the courts and attempt to frustrate a criminal trial. Helen Osamide-Akins, TVC News, Abuja.
Legal practitioner Ivan Ofeli joins us for more on this story. Mr. Ofeli, precisely what does this latest court order mean for the former governor's trial?
Well, the court is of the view that he should come to court before he can, before the court can listen to him bringing any application to ask the court for anything. The court feel that a criminal prosecution, which is actually the right thing, the defendant is expected to come to court to take his plea. As it stands now, we don't know his plea, whether he's going to plead guilty or not to the charges preferred against him, 19 count charges preferred against him. So my advice, actually, the court is not wrong by saying that, but the defendant has also shared his fears that when he comes out to the court, the EFCC, with the way they go about issues, they have the proclivity to want to arrest him and detain him. But I think that the court giving that assurance is the way to go, because at this stage, I think we have gone past the issue of arrest and detention before prosecution. Now there's already a charge before the court. Indeed. Now, whether he's coming from the detention or he's coming from his home, he's coming to be arraigned, okay? It's coming to be arraigned. So after arraignment, whatever it is, it's either the judge will remand him to custody, prison custody, or take any decision of granting bail instantly and perhaps release him on self-recognizance.
The defense counsel, Mr. Ofeli, asked for 4 weeks. What do you think would happen if Mr. Bello doesn't show up in the next adjourned date in court?
Well, there's an order of court now. There's an order of court now that he should come to court. If he does not come to court, it becomes contempt. Okay, you know that it's because the EFCC also violated the court's order in Kogi State. That was why Yahaya Bello went to court to file a motion for contempt, asking that the chairman come before the court to show cause why he should not be committed to prison. So if before that was appealed, I mean that has been appealed. Now, if Yahaya Bello refused to come in the next 4 weeks, he too will be in for contempt, okay, and that will compound his problems. So within this 4 weeks, it is expected that his counsel will prevail on him to come to court. Now the court has given an assurance, and the court will be held responsible for that assurance that the EFCC will not, you know, because once arraignment is taken, the EFCC can no longer have custody of him except he is remanded in EFCC custody. Okay. Usually he will be remanded in Kuje prison. And it's from there that proceedings would commence, because he will be granted, if the offense under reference is bailable, is bailable. So he'll be granted bail the same day. Okay, now if he's able to perfect it, if he's not able to perfect it, he'll be remanded to prison custody from where he will perfect his bail and be coming from home to attend to his trial.
All right, we'll see what happens in the next 4 weeks. Lawyer Ivan Ofeli, thank you for talking to us.